with the Hvizda Realty Group and Hvizda Training, and I'm joined today with Tim Sorensen, a trust and estate attorney with Sulloway and Hollis in Concord. Welcome, Tim.
Hi, Brenda. Thank you so much for having me.
Yeah, for sure. So, Tim, I wanted to have you join us today because I understand that there's a new House bill that's been approved that will go into effect on July 1. And it addresses the transfer of real property on death deed. Is that correct?
That's right. So the new bill, it allows for transfer on death deeds. And a transfer on death deed is essentially like a beneficiary designation for homeowners. So once this bill goes into effect on July 1st, an owner of a house or real property will be able to designate one or more individuals to inherit that property once the owner passes away. And the instrument itself, the transfer on death deed, is effective only at death. It can be changed or revoked by the property owner at any time. And it's a really exciting development in the law, and I'm hopeful and optimistic that it's going to help a lot of people.
For sure. And, it does sound like this is a big change from where we've been in the past. Tell me, why would someone be interested in having a transfer on death deed?
Yeah, great question. So in the past, probate has been the traditional means by which estates are settled and distributions are made. The probate process can be lengthy. It can last anywhere from 6 months to a year or longer, and it can be expensive and complicated. And prior to this transfer on death deed legislation, the two ways that folks were able to avoid probate were by adding a co-owner for real property, which can create a lot of risk, and also by setting up and funding a revocable trust, which can be complicated and expensive. So the transfer on death deed makes probate avoidance easier and more accessible to New Hampshire property owners.
Interesting. So, Tim, what are the requirements for creating a transfer on death deed?
So there are 3 types of requirements. There are content requirements. So the deed itself has to name a beneficiary, one or more beneficiaries. It also has to contain a legal description for the property, the metes and bounds description of the property. There are execution requirements. So the deed has to be signed and notarized. And there are also recording requirements. The deed has to be recorded with the county registry prior to the property owner's death, and also within 60 days of the date on which the deed is signed.
Okay. So you make it sound so easy, and yet it probably does still have some implications or requirements that, we don't have time to get into today. I would say if you want more information about transfer on death deeds, reach out to us. Myself or Tim would be happy to have a follow-up with you and get you some additional information.
Yes, of course, Brenda. I think that the transfer on death deed is going to be a really helpful tool, an estate planner's toolkit, and I do think that it's going to help a lot of property owners provide for their families and also avoid probate. So I'm excited about it.
That's great. Thank you.